right, folks, welcome back to another week of the Wealth Webinar Series, where every single week we bring new speakers, new topics, but it's always money. It's all we ever really talk about is money and how you can take back control of your money. And that's what we're going to be talking about today, folks. We've got Kurt from NCH here, and we're going to be talking about one of the biggest things the wealthy do with money, and that is have none of it. They, have own nothing, but control everything is, I guess, the simplest way to say it. And a lot of that is done through trust planning, trust and foundations, if you really get down to it. But really, we're going to be talking deeply about trust. Kurt's an expert in this field. And this is something that me and my wife have been very deeply engaged in, with different types of trust being set up and also foundations to not only limit the amount of taxes we pay, but also control what we have. Because, there's one thing, that you all should understand. Building wealth is the easy part. Keeping it can be the more difficult part. And that's what you got to learn. Is you got to learn, once you build it, once you start making good money and building your wealth, we got to keep that wealth. And there's a lot of people out there trying to take it from you. If you haven't noticed, not just everybody else, but the government is also trying to take some of that money back. So I think what we're going to talk about today is going to be a hot topic, one that a lot of people have been asking for. So Kurt, welcome to the Wealth Webinar Series. Thanks for coming on.
Thank you very much. It's a pleasure to be here, Chris. I appreciate it.
Oh, absolutely. And I think everybody's excited about this topic. So just real quick, can you just tell the audience a little bit about yourself and, what we're going to be talking about today, and, what problem are we going to solve?
Okay. Well, my name is Kurt Harris. I am an attorney. I work a lot in conjunction with Nevada corporate headquarters, but I do have my own firm here in Las Vegas, Nevada. I've been in practice for about 27 years, and I practice in the area of wills and trusts and estate planning. In addition to that, I kind of, as a crossover, I practice, and believe it or not, it does cross over a lot of family law. A lot of divorce and a few things like that, where property is at issue and at stake. And knowing some of these things helps me considerably in that area of my practice. I have been connected with Nevada corporate headquarters for approximately 10 years. And I am a believer in a lot of their strategies and a lot of what they do. And I have implemented some of these strategies and some of the things I'm going to talk about today in my own life. And in my own practice outside of Nevada corporate headquarters. Some things I'm going to talk about particularly are real estate privacy trusts, as we call them here. They're also known as land trusts. And they can also be known as Illinois land trusts. And just so I want people to understand me a little bit, sometimes I'm a little crass, I'm a little sarcastic. I mean to be humorous. I shouldn't have to preface that, I hope, because I think some people sometimes take me serious. I am a lawyer. I have been a lawyer. That is how I earn my living. I don't love lawyers. The worst part about practicing law is the lawyers. And so you can take all the shots at me. There's one thing about the attorney jokes, and that is that they're true. So, I mean, there is always a fragment of truth to those things. It can be very hurtful, but that's okay. I'm pretty thick-skinned. And so I am trying to educate people on how to avoid the bloodsuckers, on how to not let them take. I really enjoyed what you said, Chris. I have a friend who's a financial planner. He always says it's not what you make, it's what you keep. That really is what we are focusing on here, keeping and maintaining what we have and staying away from the predator attorneys that are out there just kind of swirling around, waiting for an opportunity to file some kind of litigation or to try and make a buck. And so I'm going to talk a little bit about land trust today, and hopefully educate some people on maybe how to avoid some pitfalls or some problems that they may come into down the road with regard to land holding, land purchases, rentals, flipping, and a few things like that. So I'm always open for questions and comments. I technologically, I'm a little disadvantaged here, but I will endeavor to answer any questions anyone has and try to give a little bit of background and foundation and hopefully cover what is of interest to your group. So
That sounds awesome. I mean, holy crap, questions are already coming in. But what we're going to do, folks, so any of you, as you're hearing about this and you're learning about this today, send all your questions to the Q&A. If you put them in the chat, we very well might miss them because we do have a lot of people on, and it's a good chance if you just chat it in, it's going to kind of come and go. So put all your questions into the Q&A like Donna's doing right now, and we will make sure we get them either throughout the presentation or at the very end. We'll make sure everybody's question gets answered. But you know, this topic is one that not a lot of people know about, and even if they know about it, a lot of times they don't know the intricacies of how trust planning works and how it can really benefit you in a lot of ways, not just keeping off the bloodsuckers, but there's a lot of other benefits. So Kurt, I don't want to go too deep into it. I always consider myself the student when it comes to this because I'm always learning about this. I might be the teacher when it comes to money and, you know, what the wealthy do, but this is an area that I'm ever evolving in. So I look very much forward to hearing what you're going to teach and adding another one right to my tool belt here.
Okay. Well, thank you very much. I'll start with a personal example, very true and very real. In my practice, I learned this. I'm going to give all the credit to Walt Disney for how this came about. Give a little historical background. I also need to tip my hat to the politicians in Chicago and Illinois who gave birth to the land trust. I really do appreciate their efforts in laying the groundwork for what I'm going to talk about here today. And I have a client who decided they wanted to invest in a substantial amount of real estate condominiums in a particular area of it was a rather old building, but it had a community association there. And so what they did, they consulted with me, and between the two of us, we came up with a plan that we were going to begin to purchase condominium units in that building. There's approximately 76 units in that building, and my clients, we just started buying them by the use of a land trust. Now, in that land trust, we bought several different condominium units in several different trusts. And so, you know, there was one that was like the Riverside Trust, the Surfside Trust, the Beachfront Trust, the this trust and the that trust, and I just named a multitude of trusts after certain areas in the region where we were purchasing. So we went about purchasing this property one by one, and we're picking them up very cheaply and very affordable. And we were using brokers in that particular area. We used different brokers and different real estate agents, and they were contacted by me as the trustee of these land trusts. We ended up purchasing approximately 15 of these condominium units, and we purchased our way into control of the entire building. And when I say we, I guess I feel like it was me, but really I didn't have anything to do with it. I signed on the dotted line, but I have no ownership in it whatsoever. We'll talk a little bit about ownership, but I was the titled owner to the property, but I am as the trustee of these trusts, but I was not the equitable owner of the property. I did not own any of the property, and none of it belongs to me. I have no right or interest in it for that matter. However, at the point that my clients finally got to the majority interest of the building, then they began doing some large renovations and began renting it out on Verbo and began making a lot more money after they rehabbed and refurbished the entire place. They took over the HOA, and it turned out to be a very profitable venture for them. And it actually benefited those that did not sell. The reason we used the trust was to keep my clients private. And secondly, to avoid driving up the cost of the other condominium units as we went about buying them up one by one. If word got out that it was coming from a single buyer that had deep pockets, the prices would have gone up substantially. And so we were able to keep the prices down on each unit because the sellers believed that they were dealing with individual entities each time and not a large deep pocket purchaser or someone that had financial backing or background. The owner actually has stayed entirely private and is unknown. He does visit the property and stay there. Nobody knows he's pretty much the owner of the entire property. He never discloses that, never says that, but apparently they think that it's owned by all these trusts, and that's the way that we like to keep it. Now, Walt Disney employed this when he went about buying up a large tract of land in Orlando. Because if somebody found out that Disneyland was trying to open up a place in Orlando back in the 60s and the 70s, they would have driven up the cost substantially on some of this swampland that they identified as being an identical place to put Disney World. And so Walt Disney is the one that seemed to have launched this, and he predicated his purchasing of that land there because he didn't want to drive up the price of the swampland of this cattle country that he was buying. He did that based on some Illinois politicians who back in the days of the railroad, when they were coming through, were buying up significant tracts of land when they knew where the railroad companies were going to pass through. And they used trust to keep the politicians private from the public eye. As they knew where these railroad tracks were going to be laid, they made a substantial amount of money when they launched the Illinois Land Trust. And so that's where it has its historical roots, and can be a very effective way of purchasing property and a very effective way of holding property not in your name. Now, the benefit of that is just really privacy. And I want to talk how is that a benefit to you? And really the benefit is that it keeps your name off of public record when a property search is done online as to who owns property. And when that comes up is if there is a potential issue at property, or there is a potential lawsuit that is filed, one of the first things that I do here in Clark County is I go to the Clark County assessor site and I look up my new target who I'm going to sue and see if they own property. What I want to know is do they have something to lose? Is this someone who has something at stake? Is this someone who is worthwhile in bringing an action against? And a lot of times, believe it or not, I can find real properties online that people own. And I know immediately, very quickly, that might be somebody who has something to lose. And that's somebody who I might be able to gain some leverage over when I initiate my lawsuit. So one of the first things I do is I quickly go to the assessor's site. Real property just says a lot about a person. It says they're very stable. It says they have financial backing. It says that they are a member of the community. It tells me a lot about them. Most importantly, it tells me they have something to lose. And so that is really the quick look. And most counties, I know there's more than like 3,000 across America, but most counties have online searches that enable attorneys to give a quick look when they're assessing or evaluating, bringing a potential suit, whether or not somebody owns a property or where the property is. I can look at that on Google and get an overhead view, and I can get a pretty good estimation about what the value is, and I can get some ideas. What this does is just eliminates that ability. Now, I know many people have searched online and they see the this trust or the that trust, and they know immediately, well, I don't know exactly who owns that, unless some estate planning attorneys recommend that you name your trust after you. I never do that. That's not our policy. It doesn't make sense to me to name a trust after myself. It seems to defeat a lot of the purpose. But in this particular case, we come up with a very some name that maybe is titled after the 123 Elm Street or some other amorphous name or something nebulous that no one can really latch onto, the Prosperity Trust or the this trust or the that trust, so that we don't point an arrow directly back at ourselves as being the owner of the trust. And so the privacy is very important to keep the predators away from you, and to keep people like me from running those searches very quickly and getting an idea that, well, maybe this is a person that has something to lose, and this is somebody that may want to pursue. At least I can go back to the client and say, look, you're going to be investing a certain amount of money in a suit, but this person has real property. This person, has something to lose. This may be something that we want to pursue. And so that is the first stop for most attorneys. I didn't learn that on my own. I was taught that as I was coming up through the ranks. That is just standard practice before we initiate a suit. And so if I could avoid that, that's a positive. When I get on there and I look online and I don't see real property, then I start looking at surrounding counties and I start looking other places to see if I can find something. But if I don't find anything, then I have to go back to the client and say, look, they don't own any real property. They're pretty transient. They could pick up, they could leave. I don't know. So I don't look at that person necessarily as having the stable roots or foundation in the community. And so it might not be somebody that we want to pursue. And so it's something you got to evaluate, something you think about. It just keeps you off the radar. And so I really do enjoy that. And I really do appreciate that. I want to explain a trust this way. It is a contract between the person who sets up the trust and the trustee and the beneficiary of the trust, who is going to receive the benefits and the proceeds of the trust. And so it's a contract, and the contract is characterized as personal property. And I try to relate all property. And this was like 6 or 7 weeks of law school here that I'm going to give you in 2 minutes. There's real property, it's dirt, and there's personal property, it's stuff. That's it. That's all the kind of property there is. There's some kind of new digital property or something like that, but that's getting way out of line, way out of hand for me. But stuff and dirt is what we have. And so what we are enabled to do is we can form a contract, which is stuff. It's a thing. And we can take a deed from property and we can put that into a trust, into a contract. So we take dirt represented by a deed, we place that into a trust, which is stuff. And now it has become personal property that owns real property. And so it's encapsulated. And my example is that it's like a basket. It's like an Easter basket that is holding a deed. I can place the deed into the basket. And now I can sell the basket by just giving away the dirt. Here's a basket. It's really expensive. You can keep the deed. It's free. I'm throwing that in. And so it enables me to sell property a little bit easier by the use of a trust. And I'm going to get to that a little bit, ease of transferability, by just selling the basket, and you can have the dirt. That's just free, but it's a real expensive basket. So one thing that I want to point out was this contract controls what goes on with my property during my lifetime, and it also controls what happens after I die. And we talk about that a lot, about probate. Probate comes up a lot. Probate is a term that came from Latin. It's a term it's called prove up, is what it stands for. Come and prove up that you are a rightful heir to property that is in probate. Prove up that you are a person who's entitled to receive benefits. In my contract, which is my trust that I have drafted, I'm going to name my beneficiaries. I'm already going to say who's supposed to get my dirt. I'm going to say who that is. And so I don't need a probate process. I don't need this to go in front of a court. I don't need a judge to look at this and try to figure out who my kids are. I'm already going to say it. And I'm not going to leave anybody out. And I'm not going to make any mistakes on that. So there's nobody better than I to know who I want my property to go to. And so I'm going to name that in my contract. My contract is going to tell my trustee, give my stuff to my beneficiaries. Just read the contract and do what the contract says. That's all you have to do. And so real estate privacy trust or land trust, like any other revocable living trust, doesn't pass through probate. So it enables me to pass the basket on to the next generation or on to the beneficiary without the aid or use of a court system. All I need my trustee to do is to take the basket and hand it over to the beneficiary. That's all they need to do. And so in this particular case, this is a very single, unified trust that just has to do with one piece of property. Just take the basket, hand it over to my beneficiary or beneficiaries, and let them do with it as they wish. And so they avoid probate that way. Probate's very expensive. You put your hands into the judges. I hope there's nobody here from Nevada. I know all the judges in Clark County. I don't particularly want to trust them with my stuff, okay, or my property for that matter. That could get me incriminated somewhere. But I trust you good people much more than I trust them. I've been in front of them all. Trust me on this one, okay? And I don't know, maybe in your jurisdictions it's better, maybe, but I doubt it. So you have the ability to avoid the court system entirely, to just draft the contract, trust, same thing, identify your beneficiaries and tell your trustee what to do. Give my beneficiaries this trust. Sell the property out of the trust, divide the proceeds, and give it to my beneficiaries. Whatever you direct your trustee to do, you can do it by way of that trust, and you will pass on that property to the next generation or to the next beneficiary without the need of court intervention. What does that mean for me down the road? I'm going to try to get back to this because I get ahead of myself too much, and I'm sorry. But that means that I might avoid some capital gains tax to my beneficiaries for a while because they might keep the dirt in the basket. As long as they keep the dirt in the basket and keep it in the trust, then there's no recognized sale of the property. And so they might be able to avoid, oh, that's not a good word, defer capital gains taxes onto the next generation or onto when they sell it. Avoidance is not the right word. It's more deferral. And they might be able to push that tax down the road, which can be very helpful to them because they're not going to have to come up with that, or they may not want to, or they may want to, if it is a rental that I have placed in my basket, that I placed in trust, they may want to continue to rent it. And they may want to continue to divide the rents among themselves after I've passed away, my beneficiaries. So they have a lot of flexibility in what they may or may not want to do. Now, the beneficiaries may want to sell it. And at that point, I want to use the careful words here, the trust will sell the property and they will receive the proceeds. There may still be a capital gains that's owed on it, or there may not be due to the stepped up basis due to a death. That may be the case or may not be the case. I'm not certain, but that might be a very good method, and that might be the way that they want to do that. And so that's what the trust is about. That is what it encapsulates. It's a basket. It does avoid probate. And the hope is that it doesn't have to be probated. Probates can be very expensive, and it's kind of a nonsensical process that I'll try to give a little bit of attention to. If I have somebody that dies and they don't have a trust and they don't have a will, then you open up a probate. You do a petition for probate. You file that with the probate court in the jurisdiction where the person passed away or where the property resides. At that point, you're supposed to gather up all the known beneficiaries, and you will appoint a representative of the estate. That representative is entitled to be compensated for their time. They usually go out and hire an attorney. That attorney is entitled to be paid out of the estate. That's all well and good for the attorneys, but that does drain the estate of the amount of money that would go to the beneficiaries, who I intended to get the money all along, but now they're paying an attorney to go out, gather up my beneficiaries, who they may already know, and to file some paperwork, which isn't a whole lot, and to represent me in court. Once they figure out who the beneficiaries are, they invite them to come to court by way of a summons. And so if I were, if I passed away, then one of my sons would come forward in the probate process. I didn't have a trust, and they would come forward and they would say that they were my child by presenting an ID. They would present a birth certificate that would have my name on it. And then they would also present a death certificate that would have my name on it as well. And that would be the probate process completed. And they would be able to make a claim for a portion of the estate. And so that is essentially what the probate process is. And that's how it takes place. Now, the next step would be just the division of the property. And essentially what happens is the probate judge will write a will for you. The process of probate involves a judge essentially just writing the will. I never wrote when I was there. And so that's it encapsulated pretty much in a nutshell. It's very expensive. And the attorneys tend to like to charge a percentage of the estate or by the hour. It just depends on what their agreement is. And so that is probate, which we wish to avoid at all costs, or any cost for that matter. So the next thing about the trust that I really appreciate and enjoy is during my lifetime, if I take this particular deed and I place it in trust, then I have the ability to transfer that to another party by whatever means I choose to do. So what I have is I have land that I bought, and I've got the deed in a trust. And so I've now placed it in the basket, essentially. I'm holding the basket, and I'm going to call that basket the Lazy Dog Trust, because that's what I call all my hypothetical baskets. It's all in the Lazy Dog Trust now, and I have appointed a trustee who is not a member of my family and who definitely does not have the last name of Harris to be my trustee. And their name is on the trust as the titled owner. In other words, they don't own any equitable interest. They have no equity in the property, but they're in name only. They are the one whose name is on that trust, and they have the ability to transfer the property at my direction. Now, the trust says that they can't transfer the property without my permission. You got to have a permission slip. That's called a power of direction. We attorneys, we charge by the words that we make up, and we try to make things up to make people confused so we can make more money. That's what we do. But it's called a power of direction letter. It's really a permission slip. And so sometimes people say to me, if I give my trustee the right to sell, they can sell the property right out from under me. And yes, that's true. The trustee could do that. Trustee wouldn't get away with it. They'd never get away with it. But yeah, they could try to sell it. The sale could get unwound. I don't know why a trustee would do that. But anyway, they have the authority on paper to sell. But I do need a permission slip before I can act on behalf of the trust. And so my trustee is going to have a permission slip from me about what I want to do to sell property. So I have several different ways that I may want to sell property. I may want to sell it out of the trust, and I would have my trustee sign a deed, a quitclaim deed, or have them sign whatever sell document they needed to sign on my behalf. Or I could sign it myself. I'm selling it at this point. I really don't care, because I have no more liability, so I'm letting it go. So I may want to sign it myself, even for that matter. Or I may just want to sell the basket. And a lot of people tend to do this particular method of sale, and we don't need a deed of trust to sell stuff. We just need a bill of sale, because now we're selling personal property that contains dirt. And so we can sell the property to another. I can hand the basket over to another party by way of a bill of sale. What I'm going to do is have my trustee resign as the trustee, and the new basket holder is going to appoint their own trustee. I'm also going to amend the trust to change the beneficiaries out of my people into whoever their people are. And I'm also going to amend the trust to take my name off it and to put the new owner's name on the trust. So we're able to sell this directly from the basket as I do transactions in my daily life. And so I can make this sell anytime while I own the property. I can sell the basket all as one, or I can sell the property directly out of the basket. I have the opportunity and option of doing either one. Sometimes the buyers, their comfort level at buying the basket is a little odd, but with some of my clients, they're used to it, and they spend very little time on their bill of sale, and the transaction is pretty quick. What are the benefits of selling the property directly out of the trust versus selling the basket altogether? I think the benefit of selling it out of the trust might be a little bit easier, and the seller might have a little more comfort, but I might realize a capital gain tax at that time. If I sell the basket, there is no transaction that is recorded with the county recorder. There's a bill of sale. Somebody now owns the basket. The trust has been amended, and now I'm passing that on to the next party. That next party, I have to caution, hey, you may have to pay for a capital gains on this down the road. We may only be deferring that tax, but I'm selling you the basket, and you can just take that on to the next thing. And so that is essentially the method that you can use to sell that basket on to the next buyer. And they may want to hold that trust for a long time, or they may want to sell the property or sell the property out of the trust at any time they want to do that. You can buy property directly into the trust. You just need to form the trust prior to the purchase and have your trustee execute whatever documents need to be executed. They're much easier to use these methods of purchase by way of a trust when it is a cash transaction. The mortgage companies get a little odd about it sometimes. It isn't they don't understand it, but sometimes they push back because they want to get as many names on the dotted line for liability purposes that they can. And sometimes the title companies also get a little sketchy. It's a little frustrating for me because title companies are just supposed to insure transactions. They shouldn't really worry about whose name is on the dotted line. They should name about whether title is clear on the dirt or whether it isn't. And sometimes I try to tell them that gently, and they generally don't appreciate it. But that is pretty much the transaction of buying and selling property by way of a trust. It is it's a simple mechanism. It's a simple process. It really isn't any different than utilizing an individual. And there are some significant benefits to that, as we've talked about. I've probably done more than 100 of those types of transactions in approximately about the last 3 years. I have I just saw a comment. I'll get back to that comment very quickly. I did see that. My fingerprints are all over these transactions, but I don't own anything. None of it is mine. However, if somebody looked me up on public record, they might think I was some kind of a land baron, but I'm not. And so that is the benefits of having that trust, is that the real owners truly are shielded from public record. I saw something about days. This isn't something I generally just, I kind of beat around the bush on this. If I had a deed restriction and I bought property in a basket, the deed restriction would prevent me from making a sale within a certain period of days or time. I don't know what that might be. 60, 90 days, 120 days. I don't know what the restriction is, but it could be for any type of restriction. If I sell the basket, there's no reason for me to record the sale. There's no reason for me to trigger a deed restriction because the property is still in the basket. The basket still holds the property. There wasn't an alienation of the property, as we say in the law, alienated. It hasn't been sold to a different party. Somebody else is just holding the basket. So it may not have triggered a deed restriction because there's no reason to record the sale because it's just a bill of sale that I sold the basket. I'm not sure if that answers that question, but I think it does.
Yeah, we'll have them
Okay.
chime in if that didn't answer the question, because
All right.
that's important, what you just said. I mean,
Yeah,
it can make things go a lot smoother. So we'll see if they have additional questions on that.
Yeah, I don't, and I thank you for that. I don't normally recommend that because I don't recommend anything that get anybody in trouble ever. But I had a lot of clients that have flipped houses that had deed restrictions, and to make money, for it to be profitable to flip, they had they had a 120-day deed restriction. They had a 60-day flip. Project was ready. They had a buyer. They sold the basket. The buyer took over the property, and I think that everything worked the way it's supposed to work, and everybody got paid. And so there really wasn't any reason to raise any red flags, and the deed restriction really didn't make a lot of sense to me. And a lot of times deed restrictions don't make a lot of sense to me. But a lot of things that are imposed by bureaucrats don't make a lot of sense to a lot of us. So I'm not really sure what that's about, but that is a means and mechanism of aiding and assisting in rental flips or property flips. These trusts are a great way to do it. On top of that, my name never hit the public record, although it may not have mattered one way or another, but it never hit the radar. It was bought in the name of the trust. It was sold in the name of the trust. And my name never went on public record with an assessor. And so there are certain benefits to that ease of transferability that you have by way of utilizing trust to make the sale. Finally, one of the things I want to touch on with a trust is it minimizes renewal fees. I get into this frequently, and I have these debates with myself. Should I use an LLC? Should I use a trust? What are the benefits? What are the drawbacks? LLCs and trusts can be used very similarly. LLCs provide wonderful holding entities for property. An LLC does require that I record that with the state. It does require a renewal fee every year. It does require that I name certain managers. In some jurisdictions, it requires that I name the members. Here in Nevada, we don't have to put the members down. We're manager managed type LLCs. And so the true owner isn't necessarily on public record, but my manager is. My manager being like a trustee. But I do have renewal fees I got to pay every year. And I got to make some kind of a tax form on my LLC. I know it's just a single piece of paper. It's not a big deal. I don't want to make it out to be a big deal, but I normally have to file something on behalf of my LLC to show some kind of a tax return or some kind of information. A trust, on the other hand, this basket is private. This basket, I can call it any name I want to call it. I can call it, I can impose on copyrights because it's a private contract. And so nobody sees it, and I can name it whatever I want to name it. I don't have any renewal fees. I don't have any costs other than just the drafting costs. So it's a one and done situation. I draft this trust one time and it's good forever. I don't record it. I don't put it on public record. I don't necessarily call it, or I don't have to worry about what I call it, and I don't have to file any tax forms. And so it's a private entity that is not necessarily disclosed, only in title, only on the name. That really is the only time it ever gets disclosed. But as far as the contents of the contract, that stays private. My beneficiaries stay private. I don't disclose any of that. So a trust is much cheaper. It's it can be a lot more efficient. It can be very quick. And as long as I don't identify the true owner, it can have some very good benefits as far as asset protection. Another issue that it comes up occasionally is that trusts do provide some asset protection because sometimes I have more than one owner of a trust, and it's very difficult to divide the equity interest of two owners in a trust because we both are holding the basket at the same time. And so lawsuits against trusts are very difficult because some states won't let you execute against a trust. They'll only let you execute on the property because they're not sure whose money is whose. And so it makes it very complicated. With LLCs, generally we have percentages broken down. We know exactly what percentage of an LLC a certain party owns, and it makes it a little more easier for me to sue the LLC for 50% of the equity ownership, as opposed to a trust where we've got two owners, but I don't know who owns 50 or who doesn't. And believe me, with my clients, they don't know either. They're not going to know. But believe me, if one of the clients gets sued, they own 5%. That's how it works with trusts. And so, and the majority owner of the 95% of the trust, they don't have anything to do with any of this. Now, tomorrow, it might be a different story. I don't know. But that's just how that works exactly. And so it's one way to stave off a creditor by putting property into a trust, particularly if we have a party who might be at risk of a lawsuit or some other, and I don't mean that in a bad way, some other, we attorneys, we get sued frequently. Doctors are always at risk of a malpractice suit. I'm not saying it's legitimate, but they are always at risk. And so those are certain situations where I might want to put my property into a trust if I'm a joint owner with a doctor, because that might be a benefit to us. Just finally, I want to give a little scenario with a trust. If there is just a hypothetical, if I own rental property and I placed it in trust, I have a trustee. It's not me. It's not a family member. It's not somebody in my last name. The property is held by the trust, and public record shows the trust as the owner. I am going to purchase an insurance policy, liability policy on the land. That's going to cover and is required, and it's prudent. I have a slip and fall with one of my renters, and they're going to sue me because it's my fault they fell down. That's how that works. And there was a known danger or something on the property that's apparently I should have known about. First thing they're going to do is they're going to file a lawsuit. They're going to serve my trustee. My trustee is quietly going to give me a phone call and say, I received a lawsuit. I'm going to say, send it over to me. They're going to send me the lawsuit. I'm going to take it. I'm going to provide that to my insurance company. And I'm going to say, take care of this. And hopefully they take care of it. We attorneys love insurance companies. It's the low hanging fruit. That's usually where we go. And that's usually who we chase after, because we are looking for the easy money. That is the business we are in. And so we usually will go after the insurance proceeds. Unfortunately, in my particular scenario here, I've purchased insurance for $350,000, pretty much the value of my property. And just hypothetically, that's the cap of my policy limit. And they are alleging a $500,000 spinal fusion and all sorts of lost wages and all sorts of problems. Now they've taken me to court and somehow they won. They had an attorney that's better than me. And now they have a $150,000 deficiency judgment. In other words, that's over and above my $350,000 policy. My insurance company is going to step in. They're going to pay the $350,000 that they're obligated to pay under the policy. And they're going to tell me tough luck on the excess $150,000. Now that's when the problem comes in, because now they're coming after my trustee because they want to know who owns the trust. Well, the trust tells my trustee that they're not to disclose who I am. So they may get my trustee under oath, and my trustee is going to say, I can't tell you. Contractually, I can't tell you who owns it, but I'm going to put you through the ringer for the next 18 months while you try to figure it out. And so they're going to need to go back to court. They're going to need to get some kind of a subpoena or some kind of a directive that my trustee needs to disclose who I am. In the meantime, I've been taking precautions. I've been hard at work over the last 18 months. Apparently that rental needed a new roof and a few other things. And I'm just not as flush with cash as I was 18 months ago. Stuff happens. And now they're coming to me for that excess judgment of 150. Well, at that point, when they finally get to me down the road at 18 months or 2 years, and they've spent probably $50,000, $60,000 trying to figure out who I am, I'm going to offer them $10,000 or $15,000 to see if we can settle this out of court, because they have provided me, the trust has given me some leverage over the course of the last couple 18 months or whatever it was, to be able to settle with them. It really isn't about me getting out of anything or me beating the system or me beating them. It's really more about giving me a little bit of leverage to help myself out. And so I'm not looking over my shoulder continuously or worrying, next time I'm going to buy a bigger insurance policy, next time I'm going to do a lot of things. But it's really about me sleeping at night and not really being that concerned about some of these things. Now, if I own a lot of properties, I have a lot to worry about. So those are things and those are considerations, but that's kind of the anatomy of how those lawsuits go. I've been involved in a lot of those lawsuits. Usually my clients end up angry at me because I didn't tell them in the first place that it was going to cost $50,000 to get to a $10,000 settlement that I'm urging them to take, because they don't want to spend another $50,000 or $60,000 to get nothing, because the person with the leverage now is threatening bankruptcy or whatever it is they're doing at that point. So it's a hard conversation for me to have in the beginning. When I'm faced with these trusts, I generally tell my clients, take the insurance money, settle the case, move on with your life. And that's kind of the tough conversation we have to have. And so that is kind of the overview what I wanted to let you know and get out today. Thank you so much.
That was interesting. We got a lot of questions too, which is good. But that example of where, that lawsuit, and then they get that judgment above and beyond what the insurance company pays. I had that situation happen. If I'm not mistaken, it was 2009. I used to own a strip mall, and one of the contractors we hired was up on scaffolding, hanging a sign, somehow fell off the 2-foot high scaffolding, broke his wrist, sued. The insurance policy was for $1 million. And because of the ladder law here in New York, he won, but then he sued. And this is now kind of after I sold the property, he sued after that above and beyond. And I believe actually won that as well. But luckily, there was nothing for him to take. And if there was, he probably would have gotten it. So it was an interesting time. I guess I was fortunate that I had nothing left after 2008. So there really was nothing else for them to get outside of the insurance policy or a big mortgage on the property. But had I had assets, had that been today, that would have went really bad if I wasn't protected. So with that, a question I'm going to ask, and then I'll get into some of the other questions, is how would this differ, what you're talking about from the LLC? So if all your properties owned in an LLC versus this, like where are the lines drawn for that? Because I know somebody had that question.
No, it's a really good question because I flip-flop back and forth on it. I think an LLC is definitely a superior. An LLC is a little, I'll characterize it this way. An LLC is a little more of a sword and a shield because I can limit my liability within the LLC. I'm going to pay for some of those limits because the mortgage that I take out is going to be a commercial mortgage, most likely with an LLC, because that's how the mortgage companies want to stick it to us. So I might get a higher percentage of interest, and I'm going to have those filing fees, and I'm going to have some other expenses associated with it. And my insurance policy might be higher on an LLC as opposed to a residential second rental or whatever the property is. So I may pay for that, but the LLC is a little more of a shield because I may just say, look, at the end of the day, all you're going to get is a hollow LLC. The property's in the LLC. I'm going to put a new roof on it. I'm going to do all kinds of stuff. I'm going to get a second mortgage. I'll do whatever I have to do. I'll pay some other debts, and I'm going to hand over the LLC to you at the end, and that's going to give you that leverage there. That may not work if they can get the LLC pierced, but that is pending them being able to pierce it. The land trust is more of I own 30 properties, and I don't really see 30 LLCs. It's pretty expensive, and so I have the ability to put it in this trust, and really, it's really more of a shield. It's not a sword. I'm just trying to shield my identity. What you don't know about, you can't get to. And so if I can keep my identity quiet, then you never do get to me. So ideally, it's more of a shield, and the LLC can be much more of a shield and a sword, but you are going to pay for that. And so with a lot of my clients who have a lot of properties, they just can't. Managing the LLC is like a full-time job. I just can't. I can't deal with it. It's just killing me. And the trust is zero maintenance. It's a one-time drafting fee usually and setup, and that's it. And so with a lot of us who are buying and selling or own a significant amount of property, or we might be in conjunction with somebody who could potentially be sued. I brought that up. Then the trust would be superior to the LLC. In other situations, if I'm in an ownership with somebody maybe that I don't know really well, or we're having fractional interest in property, then the LLC is the only way to go. And so those are kind of I flip-flop back and forth on it all the time because there are benefits and there's drawbacks to each. But I would encourage one or the other, and in some cases, both.
And I think you kind of covered this. One other thing we did when we were really big into real estate, we were doing a lot of wholesales and double closes and wholesales. And we were using land trust. We were buying the property in the trust, and then we would literally just sell the trust with the property in it when we got done. It was kind of just like, we're just done. And it just saved us, like you said, it saved us all that headache with the LLC and all the expenses. That's kind of what you were talking about with the basket, correct?
Yes, that's it. You bought the property into the basket at wholesale, and you didn't look over your shoulder at all. You just sold the basket to the next buyer, and the next buyer was probably a pretty savvy buyer, probably knew.
Their attorney, I remember the buyer was like, "What is this? I don't understand this." But their attorney's like, "Actually, this is better. Let's just do this."
Better. Right. So just take the basket, and now you're going to hold the basket. You carry it. You amend it so that you change it to fit your life, your scenario, your beneficiaries, your trustee, and it's a quick sale, and it's a bill of sale. It's a couple of pages, and we didn't involve any mortgage companies. We didn't involve any title companies. We didn't involve anybody. You have the title out of wholesale, and you're saying, "Hey, I haven't done anything to it. I'll sign whatever you want me to sign, but this clean title. You're getting what I got. I'm just handing the basket over to you." And so it can be very beneficial to buy that way. it's very beneficial to sell that way. It's really a good way of doing a real estate deal.
It was so clean. I loved it. And the attorneys loved it. The only person that was kind of a little leery was the buyer, just because they weren't savvy. They didn't know what was going on. And I had to kind of explain it the way I didn't use the word basket. I just said, you're just taking the whole thing. The property's in this trust. Just take the whole trust, just change, the trustee and the beneficiary, and we're good. And you can just have the whole thing. For me, it was just a lot more nimble. I didn't have to deal with partners in the LLCs or setting up a new LLC for this particular situation. So folks, there's lots of ways to use it. I'm just, and I'm no expert in this. I want to be very clear. I just have, just like Kurt, I have an attorney, that knew how to do this. So I'm like, oh, that sounds super easy. Let's do it that way. And we've done it many times. Matter of fact, right now, we've got land with a building that we were going to develop under contract inside of a trust, the same exact thing. And I'm probably going to walk away from it. And I know that the seller who's selling the property to us, they threatened suit. I said, go ahead. I mean, you could just sue, and that comes up with that shield. It was like, I didn't even flinch when they said that, because I was going to walk away from the deal. I'm just spooked by what's happening in the markets. And, but it just gave me such a peace of mind knowing that that was an option. And I don't think a lot of people know about it. So I'm glad you're bringing this. So Kurt, if it's okay with you, let's dive into some of these questions. And some of these questions might not be related to land trust. They're kind of just, a lot of questions on trust in general. So
Okay.
is it answering those as well?
Yeah, very good. As long as it doesn't get me sued.
No, I think they're pretty basic. Donna had some great questions. She was one of the first ones coming in. She said, can you set up a trust/foundation for the purpose of a cause or nonprofit type of goal and still donate and contribute your personal income into that? Or are you prevented from doing that if you are the founder of it?
Yeah, I think you're prevented if you are the founder. They call it kind of and it's not a bad word necessarily. They look at it more as a self-dealing type of scenario. Anytime you deal with a foundation or a nonprofit 501c3 or whatever, they get very sketchy about self-dealing and anything that has any self-interest in it. If you are paid a salary, it has to be a reasonable salary as defined by the IRS. It's got to be something that, if I'm a clerk, I need to be making $15 an hour, what a clerk amount is. If it's an accountant, it's got to be a certain amount, but it's all set by them. And so in order to donate your personal income, I like the creativity. It does give me concerns though. So that's just my thought.
And then she had a second question. What are the pros and cons of trust versus transfer on death? She said, I have a family member insisting, is this your broke ass brother-in-law? Sorry. I have a family member insisting that transfer on death is sufficient. I also have a lawyer friend who says probate is not a big deal and trusts aren't always that great. I've always had different opinion. Can you speak to that?
Yeah. We lawyers generally say probate's not a big deal, and it isn't. And it's not at all. I do charge $400 an hour, and it's not a big deal.
Of course it's not.
I mean it. And that is from the heart. I got kids to feed and kids in college, and it's about me. So no, it isn't really a big deal. But it's an unnecessary expense, I guess. It makes no sense. And then the fact that I'm going to turn over my stuff and my land to some yahoo, like I said, I just hate do they do what's right 90% of the time? Sure, of course they do. But then my estate pays for it, and so it's not a big deal. It is a fine method to do it. Transfer on death. I love transfer on death deeds. Those are great. It doesn't really fit into the investment scenario. It avoids probate, and it's the right thing to do when it avoids probate. And I love a transfer on death deed. You do need to name your beneficiaries, but we're not talking about selling the property here or investing the property or rentals or usually things like that. It's just that property is going to be transferred on death. It doesn't really provide us, transfer on death provides us with zero liability protection. And so we don't get the benefit of that either. But as far as avoiding probate, transfer on death deeds are a winner. And so I don't want to talk down on them, because I think they're a great way to go for a lot of people. The worst scenario in my life, though, would be that my dad, and man, I love my dad. that he had a transfer on death deed and that he died in a car accident when he killed somebody. And now that property gets hung up in a lawsuit from his estate because of a transfer on death deed, that my dad's last act on earth in dying was incurring a lawsuit to the estate. And it doesn't avoid that either. So, that's the worst scenario ever. But, and I don't even know why I came to that, but transfer on death is a great way to avoid probate. If that is our sole singular purpose, that's the way to go. And with other trusts, revocable living trusts, it doesn't cover everything else. It just covers the dirt. That's all it's going to take care of. Transfer on death deed is just the dirt. And that's all these trusts are that we're talking about here. So yeah, it would be a winner as far as avoiding probate.
Great question. Great answer.
Only.
All right. So B said, well, we already hit this. What type of trust is it? It's land trust is what we talked about. Is it statutory or non-statutory trust?
They are non-statutory. Usually they are a private contract. And so they don't have to abide by any particular statutes. It's whatever we personally want to put in to our contract.
Great. And Jennifer has a good one here. She said, what is the best way to find out what trust planning is most applicable in the state in which I live? With simple and limited assets currently, I'm not going to spend a ton of money or a lot on trust planning yet, but I do want to be informed for tax planning and also protect assets in the event of death. That's a great, states are different.
Yeah, and I think that is what I've given here is not really so much state specific. It's really more general information. You could consult with an attorney in your area, an estate planner. I think that'd be good. I would take a lot of what I read online with a grain of salt, but get a lot of grains of salt. Read a lot online. Find out where the similarities lie with a lot of what you read online. You can get some information off of the state bar website from the jurisdiction that you happen to be in. Sometimes that can give you some good information. I don't want to, and I'm really a big advocate of don't necessarily listen to one person. But when you get a lot of opinions, look for the areas where those opinions are united, and that'll give you some very good ideas and some very good information that you can rely on. But I wouldn't necessarily listen to just one person.
And I'm going to comment on kind of what you said and on Jennifer's question. I don't know how many of you have actually gone online and Googled trusts, or you're trying to learn about trust, but if you did, you probably stopped real quick. There's so many different types. There's so many different things they can do. In doing that, unless you've literally got a whole lot of time to waste and kind of siphon through the stuff that doesn't apply, it's going to be a dead end and a huge waste of time. Kind of like what Kurt said, your best bet is just get an estate attorney, someone like Kurt or Kurt himself, and have them understand your needs and goals and make the suggestion and the recommendations that are applicable for what you're trying to do, versus just trying to be a generalist and say, oh, I want to learn about trust. I'm just going to go on Google. Good luck. That's all I can tell you. I've done it, and I stopped literally in about 5 minutes and just called an attorney. All right. So B said, with the land trust, can I be the trustee? If not, why? Is it true that the trustee controls the trust?
Yes, the trustee controls the trust, but with permission. They really got to have that permission slip to abide by the contract, because I'm signing the contract too as the trustee. And so I'm bound by it. And so I need the permission of the true owner or the grantor to do something with the trust. The reason why I don't like you to be your own trustee, the answer to your question is yes, you can be the trustee of your trust, but now you just lost the privacy aspect of the trust and you sort of outed yourself to me. And so, yes, you can do that, but now you're the first person I turn to for your tenant or whoever happens to be there. You're the first person I'm going to name on my lawsuit as the trustee of the property to give me the information about who the owner is. And so it isn't so much that they won't eventually get to the information. If they want to spend enough money, they'll get there. I don't know why they would, but they may. But the point is that they would get to you very quickly if you are the trustee. Can you be the trustee? Yes. Do I recommend it? Please don't.
Yeah, that was a great answer. It's kind of defeating the purpose of the shield.
Yeah.
All right, Jade said, I have a revocable trust. Can you speak to the benefits of a private foundation? As a business owner, I want to fund it from 3 separate entities, construction, manufacturing, and leasing, and place a few high net worth properties into that foundation. Intricate.
Okay. You know, I'm not a foundation guru, but you're putting that, when you put that property into the foundation, it's kind of no longer yours. And so that's the part that concerns me, is because I have heard a lot of, well, I want to set up a foundation, but I want to maintain control. And part of the problem with the foundation laws or the rules, technically, you're giving up all control to the foundation. And now you may need to set up a board of directors who now are going to make directives or make the decisions or determinations over your foundation. The IRS doesn't like your foundation if you put too many of your family members on that board. They sense, again, the self-dealing, and so they want to take that away from you. I love the idea. I love what you're thinking about. I just want to make sure that when we're talking about you putting property into the foundation, now at this point, you no longer own the property. You don't have to worry about any asset protection or any liability protection anymore, because it isn't yours anymore. And so you've kind of given it up, or you've acceded your interest in it over to the foundation. You don't get to revoke that foundation. It essentially has the property now and will manage it from that point forward. You can stay on the board, but you'll have to put other members of the board on, and you'll have to be careful so as not to self-deal for all your funding and whatever you're going to do. And so that's kind of the part that it makes me a little leery. But if you're in a position where you could do that, I think that would be fantastic.
Yeah, and Jade, just on that one, you know, at the end of today, we've got the next 2-day money multiplier event, and we do have someone coming on to speak about foundations, and they might be able to kind of give some clarity. But yeah, just make sure you kind of fully understand the ramifications of doing something like that. JP said cost associated with the trust. So what does it cost to set up a trust? Is there any ongoing cost for having a trust?
Yeah, no ongoing trust. The trust does say that you're supposed to pay your trustee $250 a year. I don't think anybody does that. Usually the trustee is helping out a friend. They don't have to do anything. There's generally no cost associated with it. And I'm not sure exactly what, say, NCH charges for one. So I don't want to say something wrong, but I think it's maybe $700 or.
Yeah, they're not expensive.
Yeah, no, they're not. And that's a ballpark. I hope nobody holds me to that. But yeah, it's a one-time cost, and there is no additional fees.
Right. And that's why we used it, like, you know, JP, that's why we used it the way we did for that wholesale deal or that double close deal, is because of it was so inexpensive and there was no ongoing cost. If for some reason we had to keep that, it was very nimble, and that's what we liked about it. So Dexter said, so for clarity, for what I just heard, for my current mortgage, which sits on land that the HOA controls, if I put that into a land trust, which I have a mortgage on the structure in the condo, my personal name will not come up at the assessor's office?
No, it wouldn't. And I just a point of clarification, if this is your personal residence, I recommend you put that into your personal revocable living trust. These land trusts, for the most part, I generally recommend them to go for the second property. The next property is the recommendation. Some people do put their personal residences in them, but sometimes that has to do with they had a prior divorce, or there's some other issue that may be driving that makes a lot of sense. But for the most part, your personal residence would be in that. And yeah, I get HOA notices as the trustee frequently, and I just forward those to my owner, to my client, and then I charge them for the stamp. But that, yeah, I mean, that's kind of a, you know, there may be a cost associated with forwarding that mail. But yeah, I get some angry HOA notices occasionally. Sometimes I just open them up and or assessor's notices, and I just scan them in and email them to the clients or to the customers, whoever that happens to be. So yeah, their name does not show up. And I've been called into a couple of meetings, HOA meetings, and then they just showed up and said, well, I'm just here on behalf of the trust. Didn't necessarily, I'm Bob. I'm here for the trust, for the property. So
love it.
Yeah.
All right. Felicia said, can a trust hire employees, operate a business, and everything an LLC can do?
Yeah, they can. It's not preferred. Because at the end of the day, without filing that separate tax return, all that comes back to you personally under the trust. And this is for IRS purposes or reasoning, which is wholly different than the asset protection angle that we're talking about. So when you do have these, you are incurring certain liabilities with your employees and certain paperwork you have to fill out as the employer. And I would much prefer that that were done through an LLC or some other more formal corporate formation. It was just a better way.
And then Donna said, if you set up a oh God, I can't ever say this word, but a charitable trust, we'll just call it philanthropic. How do you say that?
Philanthropic. Philanthropic.
Philanthropic. I just got to break it up in three things. Philanthropic. Got it. A philanthropic trust, can it donate money to a 501c3 that was also set up by you?
Yeah, I believe so. Absolutely. The donating part is the easy part. The getting the money back out is the more difficult part. And that's the part where I've run into some problems with some 501c3s, is that the IRS just thought it was self-dealing, just the way that it was structured or the way that it was set up. You know, they get something in their head, they think it's self-dealing, and then they will reject the application for a 501c3 status. But as far as the donating, you bet. Yeah, no problem with that.
Great. These questions are great. Anonymous said, I heard of a real estate privacy trust that works like an LLC, but don't have to pay a franchise. Oh, this is California. Pay the franchise tax in California. Does this really work? How about Wyoming Statutory Trust?
Yeah, okay. Wyoming Statutory Trust is very much similar to what we're discussing here. Illinois Trust, like I said, a lot of names, depends on where you're at. Kind of us attorneys to hide in the ball a little bit to try and make a few bucks. But yeah, they're all very similar in operation and in construction. The franchise fee in California. Oh man, California is tough, and I have drafted quite a few that have gone to California. I know, and I think you just try to keep it quiet. And when it does come up, I think you try to push back. And the way that you push back is this way. The real estate privacy trust or land trust is a revocable living trust. There's pretty much two kinds of trust: revocable, irrevocable. This is a revocable living trust. Inter vivos is the word they like to hear. It's more Latin nonsense. But in life, living trust that can be revoked, that's what it is. And so with these franchise requests, because California is looking for any which way to make a buck so that they can refund billions of dollars. And sorry.
That's all right. Keep going. I think everybody would like to hear that.
Anyway, no, it's a great idea. They're going to give money back now, which is good. Anytime we get money back, that's a good thing. So they're looking for ways to make money. Everywhere states are strapped for cash, and they're always looking for ways to make money. These franchise fees are one way to make money. This is a revocable living trust. It should not be charged a franchise fee. You have to push back. You have to fight. And so it's just wrong to charge a franchise on it. Although they're going to say, you got to pay a franchise. If it comes up, that's what they do, because that's what their computer screen tells them to do. And so you have to push back on that. You have to make certain applications or allowances and try to avoid that, because it is specifically, it is a revocable living trust and shouldn't be charged a franchise fee. Shouldn't.
So you gotta stand up and fight for that one.
Yeah, I got a little animated. I get a little cranky about it because
That's all right. That's good. It makes it exciting. Julie said, if you have a stock sale within a trust, capital gains would apply. Is there a way to mitigate those gains upon disbursement? I don't think so.
No, I don't either. If somehow you could keep it in the basket and trickle it out over time. Like for instance,
Does that have to be a complex trust?
Yeah, I mean, it's kind of what you're talking about there. Exactly. But just by way of interest, I have a land trust in hold some rental property in Utah. But my son mows the lawn there, and I pay him a lot to mow the lawn. He's a very expensive mower. and way more than he's worth, almost the cost of what his tuition that I was going to have to pay anyway. But so I'm able to essentially defund the trust with some of his mowing fees, which I can offset a little bit of the money that way, a few things like that. And so there are ways to essentially eliminate some of the profits by way of labor and a few other things that you're going to pay out. So I don't know that that's going to work in this particular scenario, but I don't know how to avoid that exactly. Once the sale occurs, I think that the 1099 or whatever it is goes off to the government, and now they're looking for somebody to pay the gain.
And again, Julie, you know, the 2-day event that Shauna posted the link for, that would be a great event for you to attend. We'll cover things just like that. You know, we'll have CPAs on there. We'll have someone who does foundations and some work with that. So that might be a really, really good way to get that answer to the question. I don't know. And I don't know if there is a way, but if there is, the people on that 2-day will know. Catherine, if you, let's see, she said, if you have a sick family member who is confused, what do you suggest for us to do to avoid probate?
That's a tough situation because they need to be lucid when they sign the trust, or when they sign, in this particular case, it might be a transfer on deed or a transfer on death, a TOD deed. They need to be lucid. What does lucid mean? On a particular day, as an attorney, we're told that we're supposed to look at somebody to see if they're competent. But competency is a pretty low level at law. I got a few kids. That one over there might be one of them. I got 4, maybe 5. I own some land. I'm sitting in my home. That's my TV. That's pretty much lucid by law. And so if you can get a day of lucidity, then that might be the time to get a power of attorney signed, to be able to execute that, or to be able to get the trust executed, or a transfer on death deed potentially, as long as you have a good day of lucidity. If you do not, it is very problematic. And I don't have a very good answer once somebody is no longer competent to sign, because it can be unwound. They call it a fraudulent transfer. It's not necessarily fraud. I don't mean to use the big word, but it's fraudulent transfer, which means fraudulent transfers are any transfer that are suspicious or suspect that can be undone. And so it's not meaning you're committing fraud. It just means that this may not be done. This might be unwound, and it may not particularly stick if it is challenged. And so, but I would look for a good day of lucidity and see if I can get the documents signed.
Okay. JP said, how many attorney hours for the average trust setup? Is it a flat fee or is it by the hour?
Yeah, it's usually a flat fee that I know that it's charged by ACH. Usually it takes me, I've done so many of them. I don't want to diminish it, but yeah, you know, usually an hour to somewhere a little bit over. It depends on what people are looking for. Sometimes 2.
Yeah, all the trusts that I've set up are a flat fee. The ones that I've done, especially the land trust. Do you provide any other non-statutory trusts beside land trusts? You do all trusts, don't you?
Yeah, we do quite a bit of. They have an irrevocable that they use, a family security trust, and just a revocable living trust that I recommend to everybody. Just because I'm not a fan of probate. I think that's a way of saying I hate it. But yes, we have several different types of trust that we have that here at NCH.
Okay. Let's see how much. Well, we already went over how much they charge. Catherine, we'll get clarification, but I think it's like $700. That's our best guess, but we can get clarification on that from NCH. And then so this is a kind of a interesting one. Why would I need a land trust if I have a non-statutory trust with a segregated individual trust for each property? That's way above my pay grade. I don't understand that one.
You probably wouldn't, unless your name was attached to any of those properties. And then we would come back to privacy, some way of not having your name on any of those transactions. But other than that, it probably wouldn't make sense.
Okay. Yeah, I read that twice and I'm just thinking, I don't have a clue. So
yeah, this person's quite advanced. They have something good.
For sure. They got something good going on there.
Yeah.
So
Yeah.
that was great. That was 21 questions. And, Kurt, a lot of credit to you. Like, you really know your stuff, because there wasn't one where you even like had to think about it, had to pause, had to be like, well, I don't know, let me get back to you. So that was amazing. Folks, I hope you guys learned something about trust, but I mean, I've used them, the land trusts and in other trusts, but specifically these, and they are awesome. They work really well. If you're looking to kind of do some of the things we discussed, this is a great use for it. Kurt, how would they go about getting a hold of you or learning more about how to, look into setting one of these land trusts up?
Yeah, I think if they just give NCH a call, they would, and I'm not sure if they have that number there, but I can give out the legal department number. I'm sure they'll love me for that. It's 1-800-508-1890. 1-800-508-1890. And they can get a hold of somebody there who can get them in touch with somebody who'll be happy to talk to them. Or they might get stuck with me, poor souls, but nobody wants that.
So folks, when we send the replay of today's training, we'll put all the contact information in there so that you can ask more questions, figure out, what is the cost to set up the land trust. It certainly is less than an LLC. That's what I will tell you. It's a lot less headaches too. There's just really no moving. I love how you called it a basket, because like as you're talking about that, I'm like, yeah, it's exactly what it is. Like, you take a basket into the grocery store and you just start filling it up. It's kind of the same darn thing. Super simple. One last question just came in here. There we go. We got the link up there. We also have the calendar link so that you can set up a call with them to ask any questions that maybe we didn't hit here. But Rodney said, if you put your rental property that's in your personal name into a land trust, do you take the usual tax deductions on your personal tax return?
Yes, you do. Yeah, nothing changes at all.
Yeah. Rodney, it's just a shield, remember?
Yeah, now it's a shield. And your name was on public record, and I saw that it fell off when I ran my search. So I assume you sold it, or maybe you didn't. I don't know. But at that point, I don't know. But you were there, and now you're not. And so, yeah, you can still get the benefits of the shield by making the transfer if it's already in your name.
Yeah. And Shauna just put up another couple things, because all of you are part of Money School. They've got a dedicated bat phone for all of you. So I guess don't call that first number I put up there. Call the other number. Yeah, you don't want to call. So I almost wish I could just delete that. Do not call the 81 or 1890. You want to call the bat phone, which is the number that she just put in, the dedicated call-in number. And that is, specifically for this. So Kurt, that was fantastic. Thank you so very much for your time, your knowledge, and your expertise in this category, because it's an important one. And I think everybody should start learning a little bit more about how to be nimble and use that shield. And, and most people already know how to use the sword.
You bet. Well, thank you very much, Chris. I really appreciate it.
All right, folks. So one last thing that I want to mention here, and some of you went to the last one, but just as we're kind of doing this, I'm going to share my screen here real quick. And I want to show you, we've got an awesome event coming up. It's let's get the cost rate out of the way, because everybody wants to know fees, how much, $50, 2 days, $50. Okay. We wouldn't even charge, but when we charge, we find that people actually take action and take it more serious. So here we go. We've got the Money Multiplier Advanced Infinite Banking Training. It's the 2-day event. Okay. If you came to the first one, this one will be different. There might be like 2 or 3 overlaps, but we've completely revamped it. Shauna spent hours and hours, and if everybody could just say thank you to Shauna. She spent hours and hours going through the feedback from the last 2-day event on everything all of you wanted, didn't like, thought could be better. And believe me, we made it better. This event is going to be off the charts. We're going to be covering a whole bunch of stuff. Day one, it's May 22nd. And May 23rd. Those are the dates of the events. We're covering so much stuff. As you can see, day 1 and day 2, it's going to be all personal and business uses. We're not separating the business and the personal to each day, because we're going to kind of flow some of it in. But we do have a bunch of new stuff, like how to use IBC for your business and get some additional tax write-offs, using it for payroll, using deferred compensation. The Burr method, we're going to have Devin Burr come on and talk on how he's doing it. Some of the pros and cons of how to, do different plan designs. We're going to really turn that one upside down this time, because a lot of people were asking about the plan design, the 60-40, 90-10, 80-20, all that good fancy stuff. We're going to really go into how to multiply and how to, maximize cash flow using this. A lot of people, understand the concept, but they're not understanding all the cash flow options on how you can do it. So I could go on and on about that, but we literally revamped this entire thing. It's going to be May 22nd, May 23rd. So any of you that are looking to learn more from an advanced standpoint on this, we are delivering, and we've got lots of speakers coming on. Last time it was me and Brent doing a lot of the talking. This time we've got a lot of people coming in. Like I said, we got a foundations guy coming in to teach you how to use private foundations and how to do that for some of the stuff you're doing, including the infinite banking concept. We've got guest speakers coming on talking about their personal case studies, how they are using infinite banking in their lives for different things. So we took all your feedback, revamped it, and this is how you do it. The link is up there. I'll put it up again. It's May 22nd from 10 to 2:30 and May 23rd from 10 to 2:30. The cost is $50 whopping. So that's what it's going to cost you to come to that event. But if you guys are interested in learning about the advanced strategies of privatized banking and the infinite banking concept, that would be the event you cannot miss. And outside, I just put the link up there. You guys can register. We don't have a limited number of seats. We can take thousands of people or hundreds. Last time, I think we had 200, and we're definitely going to top that this time. So folks, there it is. And also don't forget, today at 4:30, we got the happy hour. Ask Me Anything. You guys can join. There's the link for the happy hour. And real quick, I'm just going to put up NCH's information, so you guys have the bat phone and the Calendly link, so that you guys can set up time to learn more about land trusts in different ways that can help you. So with that being said, Kurt, anything else in closing?
No, thank you so much. It was a great time.
Awesome. And thank you, everyone. Thank you for spending the time with us today on this Wednesday. And we really look forward to seeing you, well, in a couple hours at the Ask Me Anything or at the 2-day event. Or for some of you, we'll just see you next week. Same great place, same great time. Thank you all. Have a good day.